Tuia te rangi e tū nei, tuia te papa e takoto. Tuia ngā manaakitanga ki runga ki te ariki nui kuini ngā waihono i te pō, e noho mai rā ki runga i te ahurewa tapu o ngā tūpuna o tana pāpā. Kia ora te whare kāhui ariki nui tonu. Tuia hoki ngā mihi ki a rātau kua riro ki te pō. Ko te ika nui o te tau, ko tā tumu te heuheu e takoto ana ki wainga nui i tōna whānau ki roto i a Ngāti Tūwharetoa. Rātau katoa, ngā mate huhua o te tau, o te marama o te wiki o ngā rangitata nei, haere koutou, moe mai i roto i te ariki. Tātou, ngā urupā o rātou mā, ngā kanohi ora, tēnā koutou. Kei te manuwhiri tūwārangi, te manuwhiri whakahirahira, tēnā koe, nau mai, haere mai. Ki te kamupene o Norris Ward McKinnon, tēnā koutou, e tautoko tonu ana i tēnei kaupapa whakahirahira. Te manuwhiri tūwārangi kua harama i tēnei pō, tēnā koutou. O tira, e rauranga tirama. Tēnā koutou, nau mai, tēnā koutou, haere mai rā. Tēnei te reo o te mana whenua, e tuku mihi atu ana ki a koutou. Tēnā koutou, tēnā koutou, tēnā tātou katoa. Ko Linda Te Aho tōku ingoa. My name is Linda Te Aho, and I've been asked to welcome you here tonight to begin our proceedings. And I paid tribute to our ariki nui, the new Māori Queen, ngā waihono i te pō, and I acknowledged her ancestors, and also those who have passed on. In particular, I mentioned the chief of Ngāti Tūwharetoa, Tā Tumu Te Heuheu, who passed away recently, and all of those who have gone, they are not forgotten. And finally, to all of you, rangatira, who have blessed us with your presence this evening to welcome our special visitor who's come from afar to share with us some learnings tonight. I bid you all welcome to the pā, to our place, to our wharenui ko te tangata. And before we move on with the formalities of the lecture, just some housekeeping tasks. So the wharepaku, or the toilets, are here to my left, and you can see there's lots of exits here if something does happen. We are experiencing a lot of winds and storms elsewhere in our country right now, so just make a note of where the nearest exit is nearest to you. Just note this is a smoke-free venue. And the photography, filming and the use of mobile phones is not permitted during the lecture. We do have a professional photographer helping us out with our photos tonight. So that's enough from me. It's my pleasure to just offer a welcoming, a karakia whakatimata i tā tātou hui. Nō reira. Tū te rangi e tū nei, tū te papa e takoto. Tū ngā manaakitanga ki runga i tēnei huihuinga, i tēnei ahi. Tūturu o whiti whakamaua ki a tīna. Haumi e, hui e, tai ki e. I'm now going to ask Professor Tim Smith, the Pro-Vice Chancellor of the Division of Arts, Law, Psychology and Social Sciences, to the stage. Tim, nau mai, haere mai.
Ena mana, ena reo, ena ho e whā, tēnā koutou katoa. The University of Waikato is excited to be hosting Justice O'Bonsawin, the first Indigenous judge of the Supreme Court of Canada. Our law school, Te Paringa, was founded in 1991 on 3 core principles: professionalism, biculturalism, and study of the law in context. Te Paringa has a commitment to contributing to the profession by developing top law graduates who not only know the law, but know how to apply it in the broader social, environmental and cultural context to help achieve a more just Aotearoa New Zealand. We're proud of our connections with Norris Ward McKinnon and the annual Public Law Series, and I'd like to please welcome Sam Hood, the Managing Partner of Norris Ward McKinnon, to the stage.
Taparatia te mahina he pūrangi he mānianea. It's a whakatauki I understand from the late Kingi Tuhetia, po tātou te whirowhiro. And the interpretation is, let your light shine, let it shine so that the darkness fades. And for me, this whakatauki, it really symbolises the kaupapa or the purpose of this lecture. For those who choose to come and partake of this lecture and listen to the lecturers, we have a chance to go one step further away from te pō, the world of darkness, the state of ignorance, and to take one step closer to te ao marama, the word of light, a word of understanding and enlightenment. And so that's what we are here about today. Now I want to talk briefly about unicorns and pathfinders. Following last year's lecture by Justice Christian Whata, we turned our minds to 2025, and we wanted to do something different, but it had to be different, but it also had to connect back with the kaupapa that I spoke about, and so we created a bit of a mental wish list of what we wanted in the speaker, and there were 4 key parts. The first is we wanted someone who would give a talk that would be true to the bicultural foundings of this law school. The second part is that we wanted a speaker and a lecturer who would also give a talk or a speech that was connected to previous speeches. And there were 2 lectures in my mind, well, they've all been great, but 2 that really stand out. And the first was by the Chief District Court Judge, Hemi Taumaunu, in 2020, Te Ao Marama. And he used this lecture to introduce what he described as transformative change in the District Court. The Te Ao Marama model, the concept of moving from te pō to te ao marama, this pan-cultural concept he described, which was solutions-focused judging, addressing the underlying causes of the offending. And that really resonated with me, and we wanted a lecture that would somehow connect with that. But then the second lecture, which also built on the Chief District Court Judge's foundation, was the 2022 lecture by the Principal Youth Court Judge Walker. And that talk was titled, Te Ao Marama, It's a Matter of Fairness. And the judge built on that foundation of Te Ao Marama and spoke about solutions-focused judging. And he spoke about the experience of the youth court, how since 1989 it's been on its own journey towards a more enlightened world of solution-focused judging. And he provided some really interesting statistics about how issues like neurodisability and trauma really underpin what leads people to offend, and that's sort of a typical profile of people before the youth court, and how the youth court had been grappling for some time with how to address those problems. So when we were thinking about this lecture, we wanted someone who could possibly connect with that kaupapa. The third thing we wanted someone from another jurisdiction, and I remember our General Manager Carmen was suggesting, is there a Supreme Court judge out there who we can shoulder tap? And I think she expected me through a family connection of a practicing lawyer in America that somehow I might be able to wave a magic wand. And, and we probably pretty quickly worked out that part of what we're looking for probably wasn't going to happen. The fourth criteria was, if possible, a female judge we really wanted. So that was the wish list. We quickly worked out that we were looking for a unicorn. And then through a combination of what I describe as whanaungatanga, and by that I mean our relationship with some friendly judges, but more importantly, those friendly judges' relationships with people in far-reaching jurisdictions, and also through a combination of good luck, Justice O'Bonsawin agreed to come and deliver this year's lecture, which we're very grateful for. So she's been in the country for something like 24 hours, and she travelled 33 hours to be here. So I had the privilege of collecting her from the airport yesterday, and the drive back to Hamilton was a slow drive, and that's partly because I was in a branded vehicle, so you always, it moderates driving behaviour. But if I'm being a little bit honest, I think I was probably driving maybe 5 or 7 kilometres below the speed limit because I was really enjoying the conversation. Justice O'Bonsawin, incredibly relatable. She's the sort of person who you would probably describe as a friend. I'm probably going on a limb there, but an absolutely outstanding person who just makes you feel normal and makes you feel comfortable, makes you feel like yourself. And I think that's an absolute gift to be able to do that, given her high station. So a little bit about Justice O'Bonsawin's background. So a few things you need to know. The first is she was born and raised in a French-speaking, or a French family in Northern Ontario, blue-collar family. And I think that's really probably shaped, excuse me, get the right drink, her experience. The second key thing to know is that she whakapapas to a First Nations, we'd call them a tribe. It's the Abenaki people of the Odanak First Nation. So Abenaki, as I understand it, is the tribe, the iwi, and Odanak is the region. And there are something like 100 First Nations people or groups in Canada, and the Abenaki are something like 3,000 strong. I use the word strong, but it's actually a shrinking population through various measures, including, as I understand it, a rather discriminatory piece of legislation. And so they're a shrinking number, but they've produced Justice O'Bonsawin, so that's something to know about her. She told me not to get too much into a detailed summary of, I guess, the university and the career, but what I will cover off is at the age of 9, everyone needs a mentor. Everyone needs someone to push them along the way. And at the age of 9, Justice O'Bonsawin made a comment to her maternal grandmother, who was one of her key mentors. And Justice O'Bonsawin made a comment about, "I want to be a lawyer." And for those in certain backgrounds, if you've grown up in a place where university is encouraged, then you're probably going to expect the response, which is probably going to be, go and do it. But if you've grown up in a background where that doesn't really happen, you may not necessarily get the same reaction. But Justice O'Bonsawin's reaction was, do it, and you also need to be independent. You need to be able to be independent from, I think males was from guys. You need to be able to stand on your own 2 feet. Be a strong, independent woman. Don't be reliant on a man. And I think as lawyers, we professionally appreciate the importance of independence, but I also think it's a personal virtue as well. So she was quite a powerful role model in Justice O'Bonsawin's life. At the age of 12, that's when I understand Justice O'Bonsawin really started to reconnect with her Abenaki heritage. I understand there were probably reasons before that, why that happened, but not to the same degree before she turned 12. Now, I'm going to fast track this, skip over the university years because you don't need to know about the Bachelor of Arts and the LLB and the Master's degree, although I've just shared it. So Justice O'Bonsawin had a really interesting career, and I didn't really get to drill too far down into her time with the Royal Canadian Mounted Police, but we spoke a little bit about her time with serving as General Counsel for 8 years with the Royal Ottawa Health Group. And the health group, they run 2 mental institutions, there are 5 unions. It sounds like an incredibly complex career, but also fulfilling because the role would have involved strategic advice, litigation, and also research, and quite in-depth research into medical, mental health type issues, which we'll probably be hearing the icing on the cake, which are the Gladue principles, but there's a lot of sort of science that goes behind that. So 8 years as General Counsel. In 2016, Justice O'Bonsawin decided to start a PhD. And in 2017, she became a trial judge with the Ontario Superior Court of Justice. So that was 2017, and I think that meant suspending the PhD for a couple of years, but not for long, because Justice O'Bonsawin picked her studies back up again and finished in 2021, graduated with a PhD. Now, in 2022, Justice O'Bonsawin became a Supreme Court judge, and I just want to mention another mentor in her life, and we've had a bit of a disagreement as to how to pronounce his name. Justice O'Bonsawin says it's Murray Sinclair? Murray? Thank you, Justice Williams. I think it's Murray Sinclair as well. But the important point is he was the first Indigenous judge of Manitoba. But even more than that, he went on to become a senator. He chaired the Truth and Reconciliation Commission, which focused on the abuse of Indigenous people in residential care. And so Justice O'Bonsawin actually approached Murray and asked, is Canada ready for a Supreme Court judge like me? And the answer was, not only are they ready, but you've got an obligation to Canada to do it. And I can imagine the weight of responsibility hearing that would have been probably quite challenging, but on 1st of September 2022, Justice O'Bonsawin became a Supreme Court judge. I understand that your grandmother, she was able to watch that swearing in not long before she passed away, so what a powerful experience. On the personal front, and I'm going to wrap up, Justice O'Bonsawin's married to Pierre, 2 children, 4 dogs, bunch of chickens, and I think one of your last assignments before coming to New Zealand was to tend to the chickens. Pierre is a lawyer. He's an engineer lawyer who does legal work for Metallica, and they spend time travelling around the world following these heavy metal rock bands as well. So I spoke earlier about Pathfinder. Now, I don't know if your surname is necessarily a good indicator of where you're going to wind up in life, and as someone with a surname of Hood, you would say that. But Justice O'Bonsawin means pathfinder in the Abenaki language, and I can't think of a more fitting description for her given what she's done to date. So without further ado, if we can please welcome Justice O'Bonsawin to the lectern with a warm Kiwi welcome.
How is that to start when you have tears in your eyes? Jeez. So, kwai ni dobak na deliwizi Michelle O'Bonsawin na zawi wa banak al noba taplawi nonia udoza rishata dian. So I start off by introducing myself in my Abenaki language as Michelle O'Bonsawin, a proud member of Odanak First Nation, a Turtle Society member, and my parents are Richard and Diane. So my first language is French, so when I introduce my parents, it's always by their French name. And now I'm going to try to practice what Joe and Aidan taught me, because I think it's important to start off by saying hello to you in Maori. So here goes, and afterwards you could tell me, Joe and Aidan, if how I succeeded. Waikato tana koto e na iwi katoa. Well, wait. Let me just start over. I noticed that I was reading Aidan's awful notes that I rewrote at the bottom. So let me try that again. Waikato tena koto e na iwi katoa tena koto katoa. So that was a bit better. So forget Aidan's bad writing and stick to mine. I also want to thank Linda for starting off on a right foot. I wish to thank Norris Ward McKinnon and the University of Waikato Faculty of Law for inviting me to speak to all of you today. Also, a special shout out to Sam for picking me up yesterday. I made them wait because they lost my bags that they eventually found, and also for the wonderful introduction today. So, ole oni to all of you. I thought that it would be really important to talk to you about intergenerational trauma and how it has impacted our people, because my talk today is going to focus about Indigenous sentencing principles. And I hope to honor the tradition of starting off with having a good discussion about how Canada got to where we are today by looking back first at our history, because there's been a huge impact caused by the intergenerational trauma caused by all of those that attended residential schools. My family members attended day schools, and it's had a huge impact, including the colonization of the Canadian Indigenous peoples. It's led to what we see, those that were in residential schools going directly into the prison sentence and the prison system in Canada. What I thought that I would start off by was talking to you about some statistics, because I find that those are always more relatable. And it also made me look at the New Zealand statistics, because there are some similarities. When we look at the numbers in Canada in 2021, Indigenous adults made up approximately 33% of federal incarceration rates. And that is quite significant, because in Canada, Indigenous people make up 5% of the population. But what's more staggering are the numbers of our Indigenous women. At over 40% of incarcerated women are Indigenous. And sadly, notwithstanding that there has been some changes in society to improve the stature of Indigenous people, sadly the numbers keep increasing. I looked at the numbers in New Zealand, and from my research, the Maori people are approximately 17% of the population. But even more staggering is the fact that 50% of those incarcerated are Maori, which are even more significant than what we have in Canada. And what are the causes of this? There are a series of different things: the impacts of colonization, racial discrimination, and all of the intergenerational trauma caused by residential schools. What's a residential school? I'll just briefly explain to you. So imagine you're at home with your young children. When they turn school age, the Indian agent comes not necessarily knocking at your door, but entering your house, taking your child against your will to bring them to a school to basically whitewash them. They would put them on trains, send them to other provinces. So in Canada, we have 10 provinces, 3 territories. They would send them outside of the jurisdiction where parents could tentatively come to take them back home. These children were brought there, their clothes were taken from them, their hair was cut. They were told that they were not able to speak their language any longer. They were punished if they did so, if they did any of the cultural practices. They were mentally, physically, and sexually abused. Coming back to the statistics in Canada, the Canadian Indigenous people are 10 times more higher to be incarcerated than the non-Indigenous people. When looking at women, same trajectory with a higher rate. Indigenous women were 15.4 times higher to be incarcerated than a non-Indigenous woman. Not only are Indigenous people in Canada over-incarcerated, but Indigenous inmates are overrepresented also in maximum secure environments. We also see that when we're looking at conditions of bail, most often than not, bail will be denied. The over-incarceration of Indigenous people, it's not a novel phenomenon. The Canadian government has looked into this issue for a long period of time. What I thought I would do was go through a couple of the different inquiries and commissions that started looking at these issues starting in 1965. The first significant one was the We Met Commission in 1970 that looked at whether there was a system in an issue in the criminal justice system, and more particularly for Corrections Canada. They made general recommendations with regards to issues in these two realms, but they also made specific recommendations on how to deal with already increasing rates of Indigenous people at that time. Afterwards, in 1990, there was the Donald Marshall Jr. inquest. And this was, inquiry, and this was related to this Mi'kmaq man from Nova Scotia, which is an eastern province, who had been wrongfully convicted of murdering Betty Osborne, a young woman. It looked at what kind of systemic racism issues were persistent in Nova Scotia, especially with the police. The inquiry produced a lengthy 7-volume report that contained 82 recommendations, covering legal procedures for how to deal with wrongful convictions and new criminal justice system policies regarding visible minorities and police. In 1997, the Royal Commission of Aboriginal Peoples issued its final 5-volume report with over 4,000 pages and 440 recommendations that called for sweeping changes to the relationship between Indigenous peoples, non-Indigenous peoples, and the Canadian government. In 2015, my mentor, Murray Sinclair, was a co-chair of the Truth and Reconciliation Commission of Canada, and they filed a 5-volume report with 94 calls to action. These are the calls to actions that are most discussed at this time in Canada. The CBC, Canadian Radio Corporation, also has a website that will look at every recommendation that has been made and where the Canadian government, provincial, territorial governments, and different society agencies are at in responding and putting these actions into play. The document looked at a series of different issues like child welfare, because in Canada, 50% of children that are taken in care are Indigenous, so there are significant issues also in that system. They looked at education, language, culture, and very particularly at justice. The mandate was to document the human rights violations by hearing testimony from victims for a period of over 5 years. And I have to tell you, after having significant discussions with Murray about this process, he talked to me about how deeply the members who were part of this commission were affected, because there is vicarious trauma by listening to these stories, because it's not possible to be invisible and not have these issues touch you directly. And he had found it very difficult. In 2019, there was a national inquiry into missing, murdered Indigenous women and girls, also issued 231 calls to action. The inquiry examined the systemic cause of violence against Indigenous women and girls and made a series of recommendations to end the violence and ensure their safety. Later that same year, there was the Bien Commission in Val-d'Or, Quebec. This was a public inquiry established in 2016 to investigate the relations between Indigenous women in particular and how they were treated by the police of Val-d'Or, Quebec. These inquiries and the commissions consistently found that community-oriented reforms were necessary to combat the systemic discrimination faced by Indigenous people in Canada, and more particularly in the criminal justice system. They found, and I noted quite a few themes that were recurrent through these commissions and inquiries, that treatment in Indigenous communities is frequently a more effective alternative to sentencing solutions outside Indigenous communities. That community sanctions and Indigenous peacekeepers have a greater ability to protect and restore kinship networks and relationships within the Indigenous community than the colonial setting methods that are currently used. That there should be diversion programs for Indigenous accused instead of the pure traditional criminal justice system, that could dispense with issues that are sensitive to the cultural and the historical and the language needs of the Indigenous people. In 1995, the Canadian government responded to these high and increasing numbers of over-incarceration of Indigenous accused by proposing an amendment to the Criminal Code with Bill C-41. And the specific recommendation that was later put into place in 1996 was an amendment by adding section 718.2E to the criminal code that made a particular mandatory obligation for sentencing judges and what had to be considered when sentencing an Indigenous accused. And this is the wording. A court that imposes a sentence shall also take into consideration the following principles. All available sanctions other than imprisonment that are reasonable in the circumstances and consistent with the harm done to victims or to the community should be considered to all offenders. But this was the most important part, with particular attention to the circumstances of Aboriginal offenders. For the first time, the court that I sit on, the Supreme Court of Canada, assessed 718.2E in a case called R versus Gladue in 1999. Ms. Gladue was a young mother of 19 years old at the time of the offense. She had 2 children. She was pregnant with her third. She had an issue with a hyperthyroid gland that would make her overreact in certain situations. Her fiance had in the past been found responsible for battery against her. And on the night in question, they were celebrating her birthday. They had gone drinking, her sister, her fiance, and at one point, her fiance told her that he was having an affair with her sister. And in reaction, she stabbed him in the heart, and he passed away. This was the first time that the court had to evaluate whether or not a sentence of 3 years for manslaughter was the appropriate sentence to be imposed on this young woman. The court provided a 2-step reasoning process for sentencing judges when evaluating sentencing an Indigenous accused. First, sentencing judges must consider the unique systemic background factors that have played a part in bringing that particular offender before the court. Second, the sentencing judge must then consider what type of procedures and sanctions may be appropriate in consideration for the offender's Indigenous background. These are principles that many you will hear called the Gladue principles. I have to tell you that I did my PhD research into this area of the law. When we went to Arizona, Joe and I, a couple of years ago, I met an Indigenous judge, Ray Phillips from BC, who actually knew the family personally. And he talked to me about the impact that this common use of everyone in the legal field calling them Gladue principles had on the family, that it was like a re-victimization. They felt that their name was associated with this principle. And after I had this discussion with him, I'm finalizing a book at this time with regard to my research. I have renamed them Indigenous sentencing principles for that reason, that I don't want to be part of the perpetuation of the re-victimization of this family by using that name. So I just tell you that as an anecdote why I've stopped calling them Gladue principles. So to understand how Indigenous sentencing principles apply, it's really important for me to just give you a quick background about the traditional framework of sentencing in Canada. So all sentencing begins with the prime objective that sentences have to be proportionate with the gravity of the offense and the gravity of the responsibility of the offender before us. The review of proportionate sentence is dependent on the specific circumstances of the accused in every case. It informs the gravity of the offense and the offender's degree of moral responsibility. One of the main issues we look at is the issue of parity. So we're looking to see an offender in a similar circumstance, what kind of an offense would be put on this individual in question. Parity and proportionality, though, do work hand in hand. one of the other things we look at are sentencing ranges. So, for example, we have ranges for sexual assault files where a lower end will have a lower sentencing. More aggravated factors will lift the range to a higher amount. So you could have something from 10 to 12 years. Lower degree could be 1 to 3 years. So there are certain ranges, but the Supreme Court of Canada has said that judges cannot be straitjacketed by sentencing ranges that have been put forward in the past. And that's something that, as a prior sentencing judge, I always took into consideration because I never felt that I had to be bound by that particular range given their particular circumstances of an accused in front of me. So one of the things we look at, and it's mandated under our criminal code, are aggravating features. What kind of factors do we look at? So for example, whether the offense was motivated by bias, prejudice, or hate based on race, sex, or religion, even on gender, whether the offender abused an intimate partner, a member of their family, was there a fiduciary obligation, so someone in a position of authority, was the person under the age of 18, whether the offense was committed to benefit or the direction of a criminal organization, and whether the offender abused someone in a position of trust. We also then look at mitigating factors, and they could include whether the offender has expressed remorse for their actions, the acceptance of responsibility for the offense, including whether the offender voluntarily seeks to make reparations at times if they are accused of sexual assault, whether or not they go through a sexual deviancy program to make amends and to receive treatment, whether the offender honestly but mistakenly believed the lawfulness of their actions, whether the offender showed prospects of rehabilitation, including whether or not they're able to work and reintegrate themselves into the community, whether the offender pleaded guilty, and lastly, the personal circumstances of the offender, including whether the offender has mental health issues, substance abuse issues, or cognitive limitations. These different mitigating factors that a sentencing judge will look at may diminish the moral blameworthiness of an accused, but it's not always a necessity. Moral culpability, the gravity of the offense, and the principles of proportionality and parity that I've just talked about, they're not the most important factors to consider in sentencing. They are factors, but they're not primal above others. Sentencing judges also have to take account the list of statutory objectives during sentencing principles, many that I've already listed earlier. And we look at deterrence and denunciation to make sure that in certain cases of serious sexual assaults, manslaughter, violence against children, and sexual assaults may be more serious. The goal underlying deterrence is to communicate that criminal behavior will not be accepted by society. And we look at it in two ways. First, sentences target society broadly, including potential offenders, in an attempt to demonstrate the severe consequences of committing such an action. And second, deterrence in sentencing could target individuals, offenders, in an attempt to discourage them from acting the same way again in the future. However, when we're looking at the over-incarceration of Indigenous accused, we do look at these traditional sentencing features that I've just talked about. But we can't forget that the court in Gladue explained to us that there are two steps that have to be looked for that individual that is Indigenous. First, you got to look at the unique circumstances, the background factors that affected this individual. Are they a product of intergenerational trauma caused by a family member or even themselves having attended residential or day schools? Are they impacted by alcoholism, that a lot of them may have led to going into alcoholism or drugs because of what they went through as children by being in foster care and removed by their families. Also, what type of sentencing procedures and sanctions are appropriate in the circumstances? Should we be looking at, instead of putting them in jail, returning them to their community to put their sentence in their own community with their members and families? I have to tell you, when I talk about Indigenous sentencing principles in Canada, it's not always easy, because in the crowd there is always someone who has a family member, mostly women, that are directly impacted by the actions of Indigenous men. And at times I do have them approach me afterwards to say, how could you talk about Indigenous sentencing principles and why there should be a get out of jail free card for them because they're abusing our women? And I have to tell you, I don't always have the perfect answer because it's a difficult situation to be in. At times, what I could always offer is that the voice of the Indigenous woman who suffers abuse at the hand of an Indigenous man, there is a voice under a criminal code where they could provide victim impact statements, because a lot of times they'll tell me the Indigenous woman doesn't have a voice. And I know it's always difficult, but one of the avenues to come forward in this more traditional criminal justice system is for them to provide victim impact statements. And the trial judge in question, when it comes time to sentencing, will look at the victim impact statement, but along with the background systemic information with regard to the Indigenous accused that appears in front of them. So it's difficult at times to have that counterbalance, especially when it's one Indigenous member against another. And I do tell this as an anecdote because it's something that it never fails. When I speak to someone in Canada at a conference about this, there's always someone who has to mention, well, what do we do with these issues where we have two members, one against the other? And it's important for people to understand that when we look at Indigenous sentencing principles, they are not get out of jail free cards, because at times when we look at these background information, it will tip the scale. But there are other times where the action of the accused are so significant that it just cannot tip that scale. One of the things that really is helpful in Canada is in our provincial court and territorial court systems, we have sentencing circles. And this is something that's called the First Nations People's Court. It's something that's outside of your more traditional sentencing area where you have the judge sitting up on the dais and the Indigenous accused in front of us. And for me, it's something that I think is very worthwhile because it's more an Indigenous informed sentencing principle. We have a First Nation called Akwesasne, where it's not a provincial court, it's their territorial court, but they do this and they're very successful because the statistics shows that when Indigenous accused go in front of a sentencing circle, the success rates and the recidivism rates are much lower. So what I thought I'd talk to you about is just what kind of an impact does this have? That we're looking at tailoring culturally sensitive sentencing principles now for Indigenous accused, but within their own First Nation. So what could we be looking at? Sentencing circles have a lot more input from the elders in the communities, from family members on both sides of the accused and the victim. There could be at times temporary community banishment, healing lodges, sweat lodges, Indigenous specific addiction treatments programs, which are individualized for that accused. And I I think it's important just to go through a couple of the different healing circles, the key way Indigenous sentencing principles are implemented in those cases. These, when you talk to our elders, they would tell you that a lot of these sentencing circles have been used since time immemorial. For example, in my First Nation, if ever there was a criminal type dispute, because criminal was not a word in my language, we had the longhouse system. So what would happen was there was the longhouse for the men and the longhouse for the women, and there was the elder in each longhouse that would meet by the fire. The accused would come forward, and it would be these two elders that would consult the men in their longhouse, the women in their longhouse, and they together would put the proposal of what the punishment should be for that individual. And there are certain communities that want to go back to more of that traditional type sentencing regime. And it's really important because it helps organize disputes in a way that could satisfy, hopefully, the Indigenous accused, but also the victim, especially when we're looking at one Indigenous person against another. What's really important is the background information that's gathered by the elder about the family, about the community, about the traditions, to ensure that there are strengths instead of weaknesses that come out of these systems. I know I've been talking quite a while, so I think what I'm going to do now is I'm going to skip ahead to when do we use these principles outside of the pure criminal justice system. And for example, in my prior life, before I was named to the Superior Court of Justice, I was General Counsel of the Royal Ottawa Healthcare Group. And the Royal Ottawa Healthcare Group had a hospital in Ottawa and also another one in Brockville. And in those cases, these specialized institutions had general psychiatry, but also more specifically treated individuals who were found not criminally responsible or unfit to stand trial due to mental disorder. And when I started at the Royal, I used to appear in front of the Ontario Review Board. The Ontario Review Board is set up through the Criminal Code. It's a 5-member panel that's legislated. So it's chaired by a retired judge. There's a legal member, there's a public member, a psychologist, and a psychiatrist. And once the court finds an individual not criminally responsible or unfit to stand trial, they're then sent into the parallel system, which is the not criminally responsible system, and they appear on a yearly basis in front of the review board system. Every province and territory has one. And when I started at the Royal, I knew about Indigenous sentencing principles, and I knew that in 2006, the province where I have lived and worked is in Ontario. The Court of Appeal Ontario had issued a decision called R versus Sim. And in that decision, they had put forward that although the Criminal Code does not have a mandatory provision for the review boards to actually put forward Indigenous sentencing principles when they're looking at the conditions of accused, well, there was this not an obligation in the Criminal Code, but a strong recommendation from our Court of Appeal that review boards should actively use the same principles announced in GLADU about looking at the particular background of the Indigenous NCR accused. What could that mean? Well, when you have someone in the forensic mental health system, the board on a yearly basis could give the person an absolute discharge, which means that they are no longer under the purview of the board, a conditional discharge where they're under particular conditions, or a detention order where they're detained in the facility. And how Indigenous sentencing principles could have a particular role is especially when we're looking at the conditional discharge, because this is looking at, are there elder care responsible and associated with the institution? Are there elders in the community that could come and work with the individual? Are there other traditional medicines that could be put forward instead of having, not to put aside the mental health services that are provided by the institution, but to supplement that with more cultural-based healing? Are there access to longhouses? Are there access to friendship centers? Are there access to community services where the individual came from? And I remember when I started at the Royal and I was talking to the chief of forensics, I said, listen, there's this decision that came out in 2006 that I think Indigenous sentencing principles are really important for those Indigenous not criminally responsible and fit to stand trial that come through our system. And I remember I had asked, well, can I ask the review board for an Indigenous sentencing principle report? Because in the pure criminal justice system, we have what they would coin GLADU reports. I call them Indigenous sentencing reports. These are separate and aside from Corrections Canada reports, where the social worker or the corrections person goes into the community to find out that particular information about the individual by talking to elders, community members, and family members. And I thought it was really important to do the same in forensic mental health. And he had told me, Michelle, if you start asking for those reports, I'll take it out of your pay. That didn't go over well with me. And I thought that, you know what, it doesn't matter. I think that there's an obligation for the hospitals in these cases to ask for these specialized reports, because there's an obligation for the mental health facility, the criminal justice system, and Canada at large to be responsible and responsive to the needs of Indigenous NCR MD accused. And I started doing that in 2009, and I'm proud to say it was quite successful, that on a yearly basis, when these individuals would appear in front of the review boards, we would have these specialized reports. One of the issues, though, that we do face in Canada is these are specialized reports that anyone could put up a shingle and start using and creating them. At times, they're cookie cutters, so you'll get reports that are very generic that talk about colonialism and residential schools, and very generic, which are basically useless. And then you have the most advanced and specialized reports by social workers. And I think social workers are the best to be writing these reports in Canada, because they have the pulse. They have their finger on the pulse of what's going on in the community, about what kind of services are accessible. And I think that they are the best place to be writing these reports. So all that to say that we do have the traditional use of Indigenous sentencing principles since the amendments to the criminal code, but I've urged many over the years to think outside of the box of how we could be using these when we're looking at not criminally responsible and unfit accused. I also encouraged different judges to start looking at how these principles, not sentencing type principles, but the principles of looking into the individual backgrounds of Indigenous people that are dealing with the family court system, especially in child protection, that these reports could be very useful. And I know that in Ottawa, in the Superior Court where I used to sit in the past, they had started looking at whether or not we could start asking for these types of reports to be produced in child protection matters. And I'm glad to say that the pilot project is has moved forward. It's been very successful, and I'm happy with that. So I hope that by providing you a bit of the history about where we started off with different issues such as Indian residential and day schools, the impact that it's had on our people, the intergenerational trauma, how it had a huge impact, and it's something that we're still seeing today when we're looking at the high incarceration rates. A lot of people will ask me, well, what's the answer? And I have to tell you, unfortunately, I don't know what the answer is, but I think that it's a societal answer that there has to be extra funding when it comes to different mental health services, different educational systems. A lot of information and money has to be provided to families so we ensure that our Indigenous youth aren't part of that 50% in child protection. And I think that society at large in Canada has a role to play. And I think it's also an answer to the 94 calls to action from the Truth and Reconciliation Commission of Canada report that was tabled in 2015. So with that, Oleoni, Olenanawel Mazi, I want to thank you all for listening to me. I really appreciate it. Thank you.
Tiro kita vitira kota piri te maanga kota to te tangata te mauri o te motu e hoe tō waka ki ngā rua wahi atu ranga waiwai mō te kingitanga te tangi whakamutunga amatu taera aue hoki aue. Kia ora tātou, ka pai.
Just checking the sound, okay, it's on. So for Norris Ward McKinnon's been practicing that waiata, and it's a big step in our journey towards Te Ao Marama, and we're lucky to have Renika, Executive Director of McCall Lewis, to actually educate us, and Ewan McPherson stepped in when Renika wasn't there, so no, that was awesome. And your kōrero, your lecture was awesome as well, as expected. So this is a question and answer format, so, and there'll be some questions from the audience. We've got about 15 minutes. And I want to lead off with a couple if I can. And the first is, you mentioned this concept of sweat lodge, Justice O'Bonsawin. That's got my interest. What does it involve and how does it work?
So a sweat lodge is something traditional, and the goal is to go into the lodge and do offerings with traditional medicines. So it could be sage, sweetgrass, a lot of tobacco normally offered to the fire. So just as an explanation, so there are fire keepers, which are men. Our men are trained from a young age, and I have to tell you, my oldest was training to be a fire keeper until he had a really bad experience with bugs and had a huge rash, and he said, "Mom, I can't do this anymore." But so they're in charge of preparing the grandmother stones. So they're heated in a fire. When they're bright red, the women were responsible to prepare the lodge itself, kind of like a teepee. So we prepare the lodge. We'll put in all of the requirements of the different tobacco, etc. The fire keeper will bring in the grandmother stones. And then we, as women, have to wear long dresses, long skirts, and everyone is responsible to walk around the fire, provide an offering, then the flap is closed, and by a turn, everyone gets to make an offering and talk about what is bothering them and to get teachings from elders. So it really depends which community you're in, but that's how our sweat lodges work. And you could do various rounds. So for example, the last one I went, we did 5 rounds that lasted 5 hours. So everyone will do an offering. you'll go outside because it's really overpowering with the medicine and you sweat out. The goal is to sweat out everything that's bad and to take in everything that's good. And these could go on for hours. You'll go out, you'll get air, you go back in, and it starts again where every individual speaks. It's something very powerful.
And what role might a victim and offender have in this sweat lodge?
So it depends on the community, right? Because some communities, you have to have the victim who's open to actually being in the same area as the accused. And it's really difficult if, for example, if it's a family matter, if it's battery, for example. Those, I don't think you would have them. More times you'll see more of a circle, not necessarily a sweat lodge, because the sweat lodge are normally used for if they're doing men's groups. The men will all go in together with elders and they'll receive teachings, and that's more part of the criminal justice use of it, not necessarily with the victim. What they'll do instead when it's an issue where the victim and the accused are both ready to sit down with elders and family members, those are really more circles. And it's not necessarily always going to be a sentencing circle. It's just a traditional circle where everyone gets to say their piece and the elders try to help both members work through the issues.
Awesome. No, thank you for that. So I think I've got another question, but I'll come back to that later. We're going to open the floor for questions. Please make them questions, not long monologues with a question tacked on at the end, if you can, please. So, people, the floor is yours.
They're shell-shocked.
So we've got a roaming mic somewhere, I think, so just up the front, thanks.
I'm just wondering how in Canada the Indigenous sentencing reports are funded. Are they government funded, providing the funding to the Defence Council?
Oh boy, that's a huge fight. So it really depends. Most of the time, what'll happen, it's defense funded. The majority of Indigenous people are under legal aid certificates. Then there's a huge fight with, for example, in my jurisdiction, Legal Aid Ontario. They'll say, oh, well, no, we're not going to get an Indigenous sentencing principle report because you're going to get a Corrections Canada report. So the issue with that, though, is the purposes are not the same. Corrections Canada looks at corrections type issues, and Indigenous sentencing principle reports look more at the systemic background, and it's very particularized with regard to what kind of services would be beneficial for this accused. So there's a huge fight. For example, in forensic mental health, as I said, I had told the chief of forensics I was going to start asking for these reports, and he told me, well, Michelle, you start asking him, and I think he was serious, it's going to come out of your pay. And I said, no, it's not. This is an obligation. So what I would do is I would actually make a submission to the review board, and most of the time the review board would order the Attorney General of Canada to pay. So in a review board setting, it's more evident. When it comes to the criminal justice system, most of the time it's through the defense. In Toronto, there is the Aboriginal Legal Services Centre, and they actually do it on a really reduced rate, and they're specialists. So these are different social workers, community members that work on these reports, and they're very good. So they're not the ones that just put up a shingle and you don't know who they are. And they have a special arrangement mostly for payment. So I know out west, Western Canada, they have a lot of these report writers. I know that their rates are very subsidized, and they're covered by legal aid most of the time. So I would say 75% of the reports are covered by legal aid. 25%, there's a fight about who's going to pay for them.
Thank you. Great question. Next question, please.
That's the problem, because in 2018, there are two profs from the University of Ottawa. Now, the rector of the university, Marie-Ève Sylvestre and Marie-Denis Boileau, they looked at, well, what was it? Less than 1,000, but across Canada to see whether sentencing judges were appropriately looking at 718(2)E and meeting their obligations under that part of the criminal code. And the answer was no. And my research for forensic mental health is the same. So I think there's an issue. There's been an improvement about properly educating sentencing judges about their obligations and how getting these reports could inform their decision to make the right decision for that accused. Has it lowered the numbers? No, because the numbers keep going up. And that's a big disappointment, because in 1999, our court in Gladue talked about the dire issues related to the over-incarceration of Indigenous accused. In 2012, our court again looked at this issue in a case called Ipili, and the numbers have consistently continued to increase. So I think that there has to be a societal change. I think there are significant issues with regards to funding for mental health services in Canada. I don't know, I'm expecting it's probably the same here. What gets cut when a new government comes in, because all medical services fall under the provinces and territories. There are transfer payments from the federal government, but when a new provincial or territorial government comes in, what do they cut first? It's mental health services most of the time and addiction services. So there's that huge issue where there's a lack of funding, and I think that one part of the solution for our Indigenous people that are incarcerated is to have access to these services, for them to then not be part of the revolving door where they're automatically coming back in, because a lot of them don't know any different. They've always been in the system. They've been in child protection, or they were in residential school, and going to jail is just a continuation of their life pattern. So a long-winded answer to say, unfortunately not, but I still maintain hope. And that's why I've always consistently taken any advantage that I've been offered to speak to different judges in Canada and the legal profession about why these principles are so important, because I think education is the key. And if we have properly educated legal practitioners and judges to get a better understanding of how these Indigenous sentencing principles should be used, I think we will see an improvement, but it's a work in progress.
My question is,
Sorry, can I ask you to tell me your names?
my name is Cindy Barton. I'm from the United States.
Hi, Cindy.
And I'm losing my voice. You detailed a lot of studies that the government had done to identify the problems with Indigenous length of incarceration and overrepresentation in the system. But have there been any studies on what works to turn it around? Have there been any evidence-based solutions?
That's one of the problems, because we keep having these inquiries and commissions and different reports with calls to action. And you have NWAC, the Native Women's Association of Canada. You have AFN, which represents all the different chiefs of the different First Nations in Canada. They continually are working to put solutions on the table. I think that Indigenous voices in Canada have increased, where now they are more part of the solution. This Liberal government that's been in power for about 10 years, I think, has worked more closely than ever with Indigenous communities. Is it perfect? Absolutely not. But they're starting to have more voice at the table. But one of the issues, and Sam talked about this earlier, that I talked to him about, is we have the Indian Act that persists. And for example, my First Nation, Adanak, we're about 3,000 members. And one of the issues that we're facing is at one point we'll basically be what I call exterminated. Because what happens is with every generation, the Indian Act sets out who is an Indian and who gets the benefits of being an Indian. And that basically is in exchange for having taken all of the land and for the different issues that colonialism has impacted Indigenous people. So what happens is in my community, my aunts before 1985 lost their status when they married a non-Indigenous person. In 1985, the NWAC and some of my dad's aunts from our First Nation worked to put forward an amendment to the Indian Act in 1985, so then all of my aunts got back their status. Their children got status. I'm through a male line, my children have status, but, I have status, but my cousin's children, they don't have status because there's discrimination that jumps a generation through this amendment. And what happens is if my children who have status don't marry an Indigenous person, their children will not have status. So it's dwindling down in a small community like mine that has a huge impact. And the Senate has Bill I think it's S4 right now, that's trying to deal with this issue. Because for a small community like mine, this part of the Indian Act has a really huge impact. So our First Nation is lobbying with others to try to make amendments to the Indian Act to ensure our survival as people, because some of our communities are actually doing land claims. My community has just settled a land claim for not a lot of money, in my view, for all the land that was taken. But what happens is we have now infighting about what we're going to do with the money, because some of the older population want the money before they die. The younger population, and I'm of the view, is our traditions are, we always think 7 generations back and 7 generations forward. And if I think of my community, at one point, if our grandkids are no longer Indians under the Indian Act, that means that no more funding will come to our community through this regime, through the federal government. So we have to think about our future generations of how we're going to use these settlements to generate income for one day, if we no longer are recognized as Indians under the Indian Act, we'll be able to survive financially for our children and 7 generations forward. So I know I'm going a bit off track, but I'm just trying to explain how we have these impacts of the Indian Act on us, and we have AFN and NWAC that are trying to put different proposals together, one, to first survive, and 2, to try to deal with issues of societal change that has to take place to improve the plight of our people. Because with the improvement of the lives of our children and grandchildren, I would hope that that would have an impact to lessen the rates of incarceration that keep going up.
Just as an aside, just the term Indian, how acceptable is it to use that term these days in reference to the Indigenous people of Canada?
So in Canada, we don't consider ourselves Indians. We're Indigenous people. We're Aboriginal people. In French, nous sommes les autochtones. We don't use the term Indian. It was surprising because I don't know, Joe, if you remember this, but when we went to the U.S., the Indigenous people call themselves Indian all the time. And I remember how shocked I was when we went to Window Rock, how that was really common. But in Canada, that's definitely, we're not Indians. We're Indigenous people, but the Indian Act still exists and we're still Indians under the Indian Act.
Next question, please.
Yep. to the right.
Kia ora, Mum. My name is Harrison. Thank you for your talk. You mentioned that through the process of colonisation, a lot of Indigenous people were taken from their homes, taken from their lands, excluded from their languages and so on. And I imagine that that probably causes certain people to become disconnected from their culture. And I suspect that that probably goes to the reasons behind, I guess, offending and I guess that area as well. But my question for you is, in terms of the courts, are there processes or procedures or initiatives that the court is undertaking in order to help people who are disconnected from their Indigenous culture to reconnect with that culture?
I don't think necessarily the courts are doing that. I think that, for example, when Sam was talking about how we reconnected with Odanak when I was 12. So for example, my dad grew up off reserve. His great-grandfather had left Odanak because he was in the reserves, met a woman from Northern Ontario, moved because there was free farming land at that time, and that created a disconnect. Because when my dad was a kid, O'Bonsawin is a strong Abenaki name, which means pathfinder, we're proud of. But when my dad was a child, him and his brothers and sisters, they were the little savages of Sunnybury. And Sunnybury is their street name, and they were called savages. And when they played with the kids, they always had to be the Indians. They couldn't be the cowboys. And so my dad and his family suffered a lot of discrimination, and I think that it led to more being in hiding, of not proudly expressing themselves as Indigenous people. And when he was young, he used to go to our First Nation, and when I was young, I used to go, but I learned about my traditions not by my father, because unfortunately his father didn't pass them down to him. I learned them by reconnected with my dad's family and my First Nation, and I became more immersed, and with the years worked on learning my language, and so it's not something that's done in the justice system. I think it's a lot of effort by communities that are doing revitalization of languages. We have over 100 different languages. So here I think you're so fortunate, the Maori people, you have one language. There may be different dialects, but how amazing is that to have a strong language, whereas us, there's revitalization in our communities. So I would say that it's not justice-based, it's community-based, that are really trying to, one, revitalize the languages that are dying with our elders, and to continue to work with our elders and knowledge keepers to pass down these traditions and culture and knowledge to our youth and to my generation and to the future generations. Back on the left.
Stephen Clark. In New Zealand, the gathering of victims' impact statements is done by the police. At sentencing, we don't always have victims' impact statements. We don't always get to hear from the victims, more often not women, and from children. What levers do you have in Canada to insist upon the gathering of information from victims of offending?
So we don't get to insist. There's that right for the victim impact and the victim to actually come forward through the criminal code provisions. It's really the Crown's work to work with the victim to ensure that they have the victim impact statement. I sat a lot in criminal law court for 5.5 years before getting to the Supreme Court, and I have to say in the majority of the cases, I always had victim impact statements, especially in sexual assaults. And so it's something that's more common. I know for Indigenous women, though, that's not necessarily the case because there is the stigma of coming forward. There's that relationship in the community that is community-based. So I think that general population non-Indigenous, I think it's very common. Indigenous women, it's not as common. And I think for a series of different reasons. Joe again.
Name, please.
I'm Joe. Can I ask an off-piece question? What's cool about being a judge on the Canadian Supreme Court, and what's not so cool?
What is cool?
About being the Indigenous judge on the Canadian Supreme Court, and what's not so cool?
What is cool is I find a lot of my colleagues come and ask me questions. Since my arrival in our court 3.5 years ago, we've done really big Indigenous law cases about child protection and whether or not Indigenous people are sovereign over our children, and about huge title cases. And my colleagues came and sought my advice, and I thought that was pretty cool. What's not so cool is that when I first joined, and the same thing happened at my last court, some see me as you're the little token Indigenous girl, and you're just there because you're Indigenous. So it doesn't matter you're a litigator, you have a PhD, it doesn't matter. You're the little token Indian kid. So that's the thing that's not as cool. And I find as an Indigenous woman, I have to work twice as hard sometimes to prove myself. And that pisses me off.
I think that answer would have resonated with a few people in this room. Any more questions?
In the back. Sorry, I can't hear.
Kia ora, you talk about child law, and I just have a question in terms of cultural reports. You, in your practice, swam against the tide when it came to cultural reports. We have provisions in child law for cultural reports, but it seems to be underutilised. So what is your advice for those of us who are swimming against the tide?
To really be vocal. Your voice always has to be heard. And I have to say that maybe it's my personality, I don't take no for an answer, and I just persist. And I talk about it incessantly, and people get sick and tired of hearing me, and they're all like, okay, we're just gonna do it, because if not, she'll never shut up. So I would encourage all of you that are swimming against the tide, you just gotta keep going, because what's the solution then is to do nothing, and things are just gonna worsen. So at times, it's to be that voice and to keep saying it louder and louder until someone finally listens. And you know what? It's difficult at times because you're seen as the troublemaker, or the one who just won't listen. But you know what? I always said, I didn't get to where I am by being a wallflower. So, just keep going.
Kia ora, Brooke Bennett. We have iwi providers who are able to sit in certain courts and offer opinions. Do you have that over in Canada with Indigenous people?
So who provides opinions?
So our iwi providers, so our Māori people.
Oh, okay.
And our kaumātua.
Yeah, so we do have, I don't know if you would call it an opinion, but for example, in child protection matters, we'll have the Voice of a Child report, and that's someone who works with children to be able to put forward what their voice is. We have Office of Children's Lawyer who are assigned to certain files, and they're not necessarily doing a Voice of the Child report, but they will provide almost like an amicus-like report to the court of what they think's in the best interests of the child. So this is more on family matters. Are you talking about family matters or just in general? Yeah, so we do see it a lot in family matters and child protection matters. When we're looking at sentencing, well, a good sentencing report will actually seek out advice from elders and community members. So I think that their voices in a good report that's well written should be heard and provided to the court.
I'm going to jump on that pause with one more question. This one's a little bit controversial, and it relates to the cultural reports. So there's a move in some parts of the country to remove cultural reports from sentencing, and I want to read a quote from a person who's pushing that move and just get your response. And the quote is, "No crime is justified because you are alienated from your culture." How do you respond to that, Justice O'Bonsawin?
I guess I'll sound British, I'll say that's rubbish. I definitely don't agree. I think that in Canada, we've seen a trend that's been quite interesting when we're talking about Indigenous sentencing principles. There's a colleague of mine in my former court, Sean Nakatsuru, who I think is a real rock star, that looked at using Indigenous sentencing reports principles and how could we apply those to Black people? Because who are the next highly incarcerated people in Canada? They're Black people. And what do they face? They face great numbers of poverty, great issues with addiction. So I think that definitely is rubbish. And I think that sentencing judges have an obligation in Canada to look at those issues under 718(2)E of the Criminal Code. But we're seeing an evolution also in our case law about using these types of principles for other diverse groups, such as Black people and others. And I think that the more information a sentencing judge receives, the better outcome it will be, and the better fit sentence for that particular individual will be.
Thank you. We're going to end the Q&A session there, and I think we've been very well taught. I feel like tonight we've taken a giant step forward towards Te Ao Marama. I sent a copy of your lecture to the Chief Judge of the District Court, and he was quite grateful to receive it and pass on his apologies. He's double booked, but very grateful for your time and for your presence. And I'll just ask if we just give Justice O'Bonsawin one more big warm round of applause, please.
Thank you.
Kei te maraikura i au kōrero i te pōnei, tēnā rawa atu koe. Koutou Sam, ko tō firm, Norris Ward McKinnon, tēnā koutou, tēnā nō koutou. Ka whakakapi ahau i tēnei huihuinga i te karakia. I'm just going to end our formalities with a short karakia. Ka tū, te ki te kōrero, ka whakanoia ki te tarawhare. Kia taunga mana ki tanga te wāhi ngaro, ki runga ki tēnā o tātou, e hoki nei ki o tātou kāinga, ki ngā wāhi e hihi e tiana, tēnā koutou, rire hau, pai māriri.